Good morning. Happy Sunday. Hopefully this will be a quick video. This is just to address some comments in my comment section. The first thing to note is that the criminal statute that Lane Myers has been charged with, 13-2921, and then 2921.1 is, that just says that you've done this and you've done this when you were restrained. So this is the underlying statute that really has the definition of harassment in it. But this particular statute, 13-2921, has been reviewed by the Arizona Court of Appeals. It never made it to their Supreme Court, but their Arizona Court of Appeals found that it was constitutional, that it was not vague or overbroad, that it didn't violate First Amendment principles, and it did it because it's restricting conduct. This is a conduct-based restriction. A person commits harassment if a person knowingly and repeatedly commits an act or act that harasses another person. That would be harassment. Or if the person knowingly commits any one of the following acts in a manner that harasses. See, it's in a manner that harasses. Contacts or causes of communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means. People have been focusing on this part where it's contact. Oh, that's got to be communication. That's got to be free speech. But it's the issue is doing it in a manner that harasses. It is a conduct-based restriction. It is a conduct-based law. And people need to understand that it's a conduct-based law. People have been asking me over and over and over again, so are you saying that someone can't make a video about publicly available information? No, you can, as long as you don't do it in a manner that harasses. People are like, there's no difference between what you're doing making videos about Lane Myers and what he was doing making videos about the alleged victim. Well, again, I'm not doing it in a manner that harasses. There is a difference. The issue is the manner in which you're doing it. It is a conduct-based restriction. And look at the first part. A person commits harassment if the person knowingly and repeatedly commits an act or acts that harass another person. While speech may be sufficient to be an act or acts, it's still a conduct-based restriction because it's looking at act or acts. If it accidentally catches speech in it, well, then maybe you could bring a First Amendment challenge if it is catching pure protected speech. But if it's likely that if it is pure protected speech, it's already going to be in one of the following subcategories that the section doesn't apply to, like a lawful demonstration, assembly, or picketing, an investigation by an investigator or police officer, a certified and duly authorized process server. So the first part is the lawful demonstration, assembly, or picketing. That's going to catch a lot of the speech issues. The other thing is it has to be done knowingly, and there is a definition of knowingly. Knowingly means with respect to conduct or to a circumstance described by nature and find an offense that the person is aware or believes that that person's conduct is of that nature, i.e. the nature in the statute. It does not require any knowledge of the unlawfulness of the act or omission. As far as the injunctive relief that the alleged victim received, getting the restraining order against Lane Myers, that has also been determined to be constitutionally sound because it requires the act or actions to have no legitimate have to serve no legitimate purpose. There we go. So if you look at the particular act, this is the 12-1809. The definition of harassment in here, for the purpose of this section, harassment means a series of acts over any period of time. So again, we're looking at conduct, a series of acts over any period of time that is directed at a specific person and would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and that conduct in fact seriously alarms, annoys, or harasses the person and serves no legitimate purpose. So again, we're talking about acts, we're not talking about speech, although again, speech could get caught up in this. The speech would have to serve no legitimate purpose in order for it to be harassment. Now, I understand the backwards bending flips that people are trying to do to make Myers's conduct serve a quote legitimate purpose. Oh, he's a news person. Oh, he's this. Oh, he's that. You know, I understand the arguments that people are making, but they don't make any sense. One of the best attempts at arguments I saw was that the attempted or the alleged victim, Arizona Law School, what was her name? Anyway, I don't remember her name. So let me just say that that she was the director of special operations, and now she's the director of something else. Nowhere in her page does it state that she does any services for the public. Just because a business puts out a phone number doesn't mean that it's a phone number for the general public to use to, generally speaking, redress their grievances. Redress of grievance there are specific ways to redress your grievances, to have the government. And I don't even know why we're saying redress your grievances. The language in the First Amendment says that you can petition the government for redress of grievances. All of a sudden, we've made it like we are the ones redressing the grievance. It's not the way it works. You're supposed to petition the government for redress of grievances. The verb that you do is you petition. You don't redress. You petition. To petition the government for redress of grievances. So you do the petitioning, that's the verb you do, and then the government does the redress. And the way you seek that redress, well, there's different ways to do it. If it's a legal situation, the way you petition the government is that you file a petition. You file like a petition for writ of mandate, petition for writ of certiorari, petition for writ of prohibition. I mean, there's different writs that you can seek. A petition for writ of habeas corpus. You're petitioning for redress of grievance with those. If you get an adverse ruling, the way that you petition for redress of grievances is you file a motion for reconsideration. You file an appeal. That's the way in a legal situation, that's the way you petition the government for redress of grievances. People have tried to warp this into you could contact whoever you want as long as they're employed by the government and harass them to no end. That's not the way it works. That's not the way anybody understands it. Finally, let's take a look at what's happened so far. For those of you who think that my understanding of the law is bad, dumb, and wrong, let's just be clear that there have been 3 hearings to date that I'm aware of where judges have found that Lane's behavior is harassment. It's been found to be civil harassment at an initial ex parte hearing brought by the alleged victim that got her the restraining order in the first place. At the trial, where Lane Myers challenged the petition and there was a trial on it, once again, the judge, found that there was civil harassment. And then, as far as the criminal is concerned, at the no bond hearing, the judge found that there was criminal harassment by whatever the standard of proof is, where proof is evident and presumption is great, or something along those lines. I don't remember the exact text of it. It's Criminal Rule 7.2. Here it is. The proof is evident or the presumption great the defendant committed yada yada yada. So the court found in the criminal matter for the no bond hearing, at least for the purpose of the no bond hearing, that there is evident proof or a great presumption that Lane Myers committed harassment. And 3 judges have considered the actions of Lane as harassment. 3 judges. So 3 hearings and 3 separate judges. There was the civil harassment judge, who was a male. There was the no bond hearing judge, who was a female. And then the the actual criminal trial judge who made the ruling on the motion, the slap motion. He also found that there was has considered that there was harassment. Remember, the people who decide whether a law is constitutional, who decide what a law means, who decide whether you violated that particular law, assuming there is no jury in place, assuming it's a bench situation, are judges. Judges determine what the law means and what the law says. The legislature writes it, the governor or the president enforces it, and the judiciary branch, they're the ones who interpret it to determine whether or not you've committed it, what the actual law means, and whether or not the law is constitutional. So your particular belief that a law is unconstitutional is pretty meaningless unless you're a judge specifically assigned to the case. But pause for a moment and consider that judges who are educated in this, who are experienced in this, who have the benefit of law clerks to assist them in this, they're not seeing this the same way that Lane Myers supporters are. They're seeing this as, no, there's harassment. He's harassing her. So pause to consider that. Maybe I'm not a, in quotes, true patriot or whatever, but I am practical. I am pragmatic. Think about it. Judges are saying there's harassment. There's a good chance that there's harassment. Think about it. Thanks for watching. Have a great day.